I have one more question on a totally different matter, if I may. And I concede at the outset this may not be an appropriate question within your bailiwick, although I did look at the departmental plan for the current year, and it talks about your responsibility in legislative services for particularly constitutional matters. And as you may know, the Supreme Court of Canada has frequently said that privacy is a quasi-constitutional right in this country. Dr. David Flaherty, who is probably Canada's leading expert on privacy and data protection, has written about our 35-year-old Privacy Act, claiming that the act is, quote, tantamount to a cart horse struggling to keep up with technologies approaching warp speed. Internet hadn't even been invented, let alone global positioning systems, biometrics, et cetera, et cetera. How can the government not take this on as a priority for legislative reform, given explicitly its quasi-constitutional nature?
I cannot answer for politicians for sure, but what I would like to say is, of course, at the department we do study what other countries are doing to make sure that their private system evolves, taking into account digital rights, for example. So this is the work we are undergoing right now at the department.
So can I ask you explicitly, therefore, whether there is reform of the 35-year-old Privacy Act underway at this time?
What I can tell you is that, of course, we are taking into account all the evolution in terms of digital rights, as I said, and that, you know, if there is any appetite, any time to bring a reform, we'll be prepared to propose and give recommendations to decision makers.
Okay, thank you.